All right, good afternoon, everyone, and welcome to the Miller Johnson Employee Benefits Lunch Break Series on this August 18th. Thanks, everyone, for joining us. For those of you who are new joiners, please be aware that we do one of these lunch break webinars on the third Wednesday of every month at 12 o'clock Eastern Time. You can see on this slide where to register at, and you can register just for certain webinars or all of them. Our upcoming ones are on September 15, which we will be doing part 2 of maybe even some more parts of the 9 No Surprise Act. But at this point, we're just going to do part 1 today and part 2 to next in September. I think in October, just for your information, I'm going to be joined by some of my retirement plan colleagues, and we're going to address some end of the year things that you should be aware of, both with respect to retirement plans and health and welfare plans. We figure waiting until November may be a little bit too late for that. And then maybe later this year, early in 2022, we'll be back and probably addressing more updates on the No Surprises Act. Having said that, if you have other topic ideas, right now we kind of have a lot of things to cover. There was a lot of changes that apply particularly to health and welfare plans in the Consolidated Appropriations Act, which was passed at the end of last year. But if you have topic ideas, please feel free to post those in the post-webinar survey. Today we are going to address the No Surprises Act, part 1. And today we're going to be focusing on how the No Surprises Act offers emergency services protections and then plan and provider requirements. I would say this episode is going to be much more focused on kind of an overview of the emergency service protections and the plan requirements, because I don't see a lot of provider requirements. That said, I'm going to welcome my colleague Tim Gutwald here. Tim is an attorney in our healthcare practices group. So his work and I don't completely overlap, but me, I generally am working in the healthcare sector on the payer side, particularly group health plans. Tim works with a lot of our healthcare provider clients and ensures compliance over there. Tim, welcome to our webinar. Thank you for joining us.
Yeah, thanks, Tripp. I agree that I think a lot of today will be geared more towards your clients and the plans. There's definitely, especially when it comes to sort of the post-stabilization and the non-emergency care, I think providers have a little bit more to keep track of and pay attention to. I will say, though, that for the plans, there's a lot of overlap between that No Surprises Act and EMTALA that borrows a lot of definitions from the Emergency Medical Treatment and Labor Act. I run into that frequently with my healthcare clients, hospital clients, and so as plans are going to have to learn and gear up on some of that terminology, and so I think that's some of my expertise overlaps there.
That's a good point. And actually, I'm going to give you a quiz question here right now, since a lot of my providers, my clients that are on the line, including me, I've heard of EMTALA before, but I couldn't actually tell you what that acronym stands for. Can you do that off the top of your head?
Yeah, it's the Emergency Medical Treatment and Active Labor Act.
Okay.
So it's also kind of known as an anti-dumping statute. It prevents if someone shows up at a hospital and requests medical care, the hospital can't turn them away is what it amounts to.
Okay. And as you'll see through here, the No Surprise Act borrows, I guess, as you said, a lot of terminology or defined terms of art from that act. Here's kind of a quick overview of the topics we're going to cover today. And again, like I said, we'll probably hit more on the plan side today. That doesn't mean that there's nothing in here for providers, but if you are representing a provider on here, or maybe both, really, I would encourage you to join us on September 15th, as I think that side will be geared, if not more, and not exclusively, but definitely more towards providers, even, more than 50%. So bear with us today. I think there is some important nuggets of information in here for you today, but please be aware we probably are going to touch on more of the plan stuff today. So we're going to go over a background of the emergency services protection under the ACA, which currently applies, but only to non-grandfathered plans, which I think is a majority of them. We'll give you a quick overview of the No Surprises Act, or the NSA. NSA feels weird. It's I feel like no surprise when you say NSA, you're not generally referring to the No Surprise Act. What are emergency services under the NSA? So when do the when do these protections come in place? When the protections do apply, what are the requirements on group health plans and providers? Like I said, have questionnaires and we'll have question and answer period, and then we'll address again. We'll remind you of our future webinars. Moving right into the ACA. So this law, I mean, the ACA, as many of you may be aware, has protections for certain emergency services that apply, but it only applies to non-grandfathered health plans. As we'll discuss in a minute, the emergency services protections apply both to non-grandfathered plans and to grandfathered plans. So if you're one of these employers out there that still has a grandfathered plan, my guess is, your plan probably voluntarily complies with these emergency services protections under the ACA, but you're going to have to comply with the No Surprises Act. So what are kind of the protections that we see under the ACA is that, when someone presents to an emergency department of a hospital and needs emergency services, a plan has to cover that without any prior authorization requirements, even if they show up at a hospital that's out of network. They have to do it without regard to whether the provider was in network. I feel it's a little bit of a duplication of the previous requirement. The plan cannot pose any administrative requirement or coverage limitation that is more restrictive than those on in-service, in-network, or ER, or on ER in-network ER services, and then must comply with certain cost-sharing limitations. So a participant's co-pays, insurance, co-insurance, or out-of-pockets basically can't be higher for out-of-network than they are for in-network services. And then the plan has to make what we call a minimum payment amount. And that minimum payment amount under the ACA is the greatest of the median of the amounts the plan negotiates with in-network providers for ER services without regard to co-pays or co-insurance, to the amount that the plan generally pays for out-of-network services. Most of the time, I think that's UCR, or usual, customary, and reasonable amounts. Or 3, I think this is rarely that this would be the greatest, but the amount paid under Medicare Parts A and B, and that's not even with a percentage increase adjustment. Now, the key distinction I think you'll see is the plan will have to make this minimum payment, with the idea to be that kind of limits any balance billing that the participant may see. But to the extent that a provider or facility's charge is more than this minimum payment, they're going to turn around and they're going to bill the participant. So even under these ACA protections, the participant can still get balance billed. And so that's going to be a big key change with the No Surprises Act. So moving on to the No Surprises Act, the star of the show is the No Surprises Act generally provides, again, protections with respect to surprise, or what we call balance billing, and participant cost sharing in 3 specific situations. In balance billing, I think probably everybody's aware of that, but it's really whatever your insurance company, whatever insurance you have, group health plan, individual, it's not paying the full charge. Generally, as long as you're not in network and barred from a network agreement, you as a provider are allowed to turn around and bill the balance difference to participants. And if a participant is expecting that, that's one thing, right? But these situations that the No Surprises Act covers are the situations that I think most come up when a participant may not have a choice or may not be aware that a balance billing is coming, thus the reason we're calling it a surprise, right? First one, of course, emergency services provided either at a non-participating, we'll use non-participating or out-of-network kind of interchangeably for purposes of this presentation, either at a non-participating facility or a non-participating provider. Again, surprises can happen because if I have a truly emergency service, I'm likely going to be taken, whether I want to or not, to the setting that is closest to me, that can most appropriately provide care for me. And that may be an out-of-network or a non-participating provider. So I don't really have a choice necessarily in these emergency services to pick an in-network provider or facility. Second, non-emergency services provided at in-network facilities or an in-network hospital, but you have maybe a non-participating provider. I think the most common approach that you hear from on a day-to-day basis, and not to pick on anesthesiologists, I really don't mean that, but it's just the common one. You show up, you schedule surgery at an in-network facility, whether it be a ambulatory surgery center or a hospital, and maybe unbeknownst to you, or maybe buried somewhere in your consent forms, it says, you may be treated by a provider, such as an anesthesiologist, maybe even an assistant surgeon, who may or may not be in your network. And if they're not in your network, they can end up balance billing you if your insurance doesn't cover their full charge. So you, by mere act of booking your surgery in an in-network facility, you may be under the assumption that you're in-network all across the board. But with respect to certain non-participating providers, you're not. And then suddenly after everything's done, you're at home recuperating, and a bill that you are, again, not expecting, a surprise bill for the balance bill shows up. Third is air ambulance services provided by non-participating providers. I think the premise here is very similar to emergency services. If I'm in such a dire situations that I need to be airlifted to a hospital, I probably have little choice over what air ambulance service is going to come provide that transportation service. And then lastly, just to kind of by way of introduction, we're not going to talk about this yet, is the No Surprises Act also provides an independent dispute resolution or IDR program to resolve payment disputes between providers and plans. So the key is the NSA is taking the participant or the patient outside of the dispute between the difference in what the provider charges and the plan's going to pay. You're no longer allowed to look to the patient to pay that difference. Now the plan, the provider have to either are they going to be set by law the amount that's going to pay, they're going to have to negotiate it even though they don't have an in-network agreement, or they're going to have to duke it out through this IDR process. And we'll probably be back to talk about the IDR sometime in the future. We're waiting on additional regs on those. Really, the only thing we know about the IDR process is it's called, they're referring to as baseball style arbitration. And what that means is the plan is going to come to the arbitration, and it's going to present what it thinks it should pay for the service. The provider is going to come and it's going to say, this is the number that we think should be paid for the service. And the arbitrator is not going to split the baby or split the difference, if you will. They're going to pick which one they think is better. And then that's the one that's going to go, right? So they're going to pick one or the other. They're not going to split the difference at all. And then if you lose, if you're on the losing side, you get to pay for the arbitration as well. So it's kind of a, double sting there. Very quickly, the effective dates for the No Surprises Act for providers and facilities. Generally, it's just going to apply uniformly on January 1 of this coming calendar year, January 1, 2022. For group health plans, it's going to apply the first day of the first plan year beginning on or after January 1, 2022. So if you're a calendar year plan, like a lot of them are, it's also going to apply to you beginning, in 2022. If you're a non-calendar year plan, you may have a staggered implementation date. I was talking to Tim last night about this. Just by way of preview, I think this may cause some temporary unique nuances in the law, because let's say you have a plan year that runs 9/1 through August 30. So you're not going to be subject to these rules until September 1 of 2022. So let's say a participant in that plan shows up in the ER. These emergency services protections apply. The facility and the provider is not allowed to balance bill the patient. The plan pays not according to the NSA. They plan according to the current ACA practices, which is the greatest of those three amounts. Let's say it's the UCR amount, and the provider feels like that's a way underpayment than what it believes, and it says, I'm going to take you to IDR. I think in this interim, the plan can say, pound sand, we're not subject to these No Surprises Act limitations yet. You get to take it or leave it. And we're not going to IDR with you. So I don't know if the regulators have thought about that, but I'm sure that will probably pop up here and there. Thank goodness those will be temporary problems.
Yeah, and from a provider perspective, I don't know how other than contacting the plan, there's no way for you to know whether a patient's, what the effective date of their health plan, what their plan year is. So, usually plans are pretty fine to disclose that sort of information, but, it's just not a very efficient process from a provider perspective.
And for those of you, Tim and I, was it last spring, actually last fall, we did a webinar on the No Surprises Act under Michigan law. If the plan is a fully insured plan, the provider may have some recourse under the protections offered under the Michigan No Surprise Act. But if it's a self-funded plan, those plans that at least the self-funded ERISA plan, those plans are exempt from that Michigan law. So, I think that these nuances are probably going to only show up to the extent that a participant is in a self-funded ERISA plan.
I'll just add, with respect to the effective dates, as we've seen clients struggle to get the state notice requirements kind of implemented. Again, if you're an anesthesiology practice or a radiology practice who's doing a lot of non-emergent type cases, you need to try and obtain the consent or provide the notice to patients. It can take some time to work with hospital partners in preparing those and getting those put into sort of the typical paperwork and consent type process for patients. So, I really encourage providers on the line to start reaching out to your hospital clients. Again, it's going to be a relatively small amount of patients that would be, subject to that. Most of my clients are in all the same plans as the hospitals that they are in. But, you want to get ahead of this as best as you can.
Okay, we got a couple questions I want to address quickly. We do want to address questions, but I feel like we could easily be here for the rest of the afternoon.
Right.
I don't think everybody wants to spend their afternoon doing this. It's about a provider that appears to be a network that maybe doesn't want to accept the contracted rate. Wondering if the in-network hospital can balance bill the patient. There's no law that prohibits the provider from doing that, but usually the network agreement is going to say, no, we've agreed to these contracted rates, and by this agreement, you have to accept this as payment in full, along with any permissible participant cost sharing. But once you get that, the fact that you don't like that contracted rate, then you shouldn't have agreed to that. So there's nothing that I believe that's legal that would say an in-network hospital can't balance bill a participant, but that would be a contractual violation with a typical in-network agreement.
Right. Yeah. I mean, the provider payer agreements that I review, and the provider agrees to accept as payment in full for the services, whatever that in-network rate is, minus again, deductibles or co-pays or things like that. So yeah, I mean, it would be a contract law type issue as opposed to a statutory or regulatory issue.
We're getting saw a question about non-emergency service out of network. Can they balance bill as long as they get a consent? Generally, the answer is that it's yes, but that's what we're going to cover in September. So I don't want to spend too much time there. There's some notice and consent provisions and some providers that can and some providers that can't do that. But tune in September and we'll spend a lot more time about that. Also curious if you have any thoughts about how to establish an O&M rates that would be defense limit. ADR, again, another question about IDR. We don't know much about IDR at all right now. All we know, again, it's baseball arbitration. The provider cannot come to IDR with their charge master rate because the process is that's going to be artificially inflated. And similarly, the plan can't come and say with the Medicare rates because those are going to be artificially low. So those rates are off the table. But after that, I think it'll probably. IDR may have to be heavily utilized at first, but I think over time, you're going to start establishing, basically not necessarily agreed rates, but ideas that providers are going to accept because you're going to want to avoid this IDR process.
I mean, these discussions already happen, right? These disputes already occur between plans and providers where there's out-of-network charges involved, and I wonder how much the IDR will be utilized in light of the uncertainty, and both sides might just end up splitting the baby a lot of the time on what the demand is and what they're doing.
You don't have to go to IDR. I mean, the step before IDR is negotiated. We'll kind of cover that in a minute. But yeah. So the other thing I want to talk to for those plans for the people that are here to learn how it's going to impact plans, I think one thing to keep in mind, if you're in fully insured plan, this law technically applies to your plan, but also applies to the the insurance carrier, insuring your plan. And for most part, the insurance company, since they have kind of that dual obligation, is going to have to ensure compliance. That doesn't mean you might not want to reach out to them and say, what's your compliance plan? Are you ready to go? What should we be doing as an employer, if anything? Self-funded plan, truly the obligation to comply with this no surprise act is on the plan sponsor, the legal obligation. I think from a practical matter, you're going to have to lean on your TPA to comply with you. And I would say most TPA agreements, so you really are going to want to reach out, first of all, to your TPA to ensure that they have an action plan or that they're aware of this and they're ready, they know how they're going to do this or figure it out. And I would say, maybe we update our TPA agreements, but frankly, I don't see a lot of TPA agreements that, start listing every provision in the law that applies to the plan that TPA is going to do. But I do see a lot of TPAs agreements that especially when they're talking about fees, that say basically if a federal law requires us to do more, that gives us the ability to come back at you and do, propose a fee increase. And if you turn us down, we have the ability to terminate the agreement. So it may be possible that some of your TPAs are going to approach you and says, yeah, we're ready to comply with this on your behalf, but this is adding to our administrative burden. That fee promise that we gave you that has an exception for if there's additional laws that create a burden, that may come into play in this aspect. So what are emergency services under the No Surprises Act? And, I don't want to, I apologize for kind of the detailed nature of these slides, but I really try to make my slides so that they're usable by these folks, your folks afterwards, and we make these available. So I don't want to read it totally, but it's an appropriate medical screening that is within the capability of an emergency department of a hospital or of an independent freestanding emergency department, including ancillary services available to the ED to evaluate whether an emergency medical condition exists. And where you see a lot of these bolded terms, these are terms of art, defined terms that we're going to discuss later in the presentation, which you can also find in the regs.
Yeah, I would just add, just for those who are not familiar with EMTALA, a medical screening exam, a hospital is required to provide a medical screening exam when someone presents themselves to the emergency and requests treatment. So really anybody that shows up at the hospital, there's not a set thing that's a medical screening exam. Doesn't consist of just blood pressure. It depends on the presentation of the individual. So again, there might be, obviously payers are already paying for these types of services already, but this terminology might be a little bit.
And the ACA applies in a lot of these contexts too about some of that language, so it may not be totally unnecessary. One thing I want to focus on right now is independent freestanding emergency department, and this is basically a facility that is geographically separate from a hospital that is permitted to provide emergency services. In Michigan, I talked to Tim about this, generally urgent care facilities are not licensed to provide emergency services. So they're not going to apply in Michigan. These protections are not going to apply to services at urgent care centers in Michigan. That's not necessarily true in all states. I understand other states may authorize or license certain urgent care facilities to provide emergency services. And in that case, that urgent care center would be an independent freestanding emergency department to which these protections may apply if it is truly an emergency. I can think of one freestanding emergency center on the southwest side of Grand Rapids. Otherwise, I can't think of a ton of them, at least in the greater West Michigan area.
Yeah, that's the only one I'm aware of in West Michigan. But yeah, just like you said, urgent care centers are not independent freestanding emergency departments under Michigan, and they can't sort of accidentally become one by the nature of the condition they're treating. Yeah. So if that's where the bill is coming from, then this isn't going to apply.
If they do some type of treatment for what's an emergency service, even if it's to basically somewhat stabilize a person to get them to an ER, they're going to be able to balance bill someone, because typically those facilities are out of network because these protections are not going to apply. So emergency services also includes further medical examination and treatment as may be required to stabilize the individual. And this is true even if it's not happening in the hospital's emergency department, right? So if someone presents in an ED with an emergency service and they're basically transferred to another department for stabilization like the ICU, the protections are still going to apply even though they're not, this law is not limited to just the services that are going on in the physical boundaries of a hospital's ED.
Right. I mean, and the other common area where this will, where emergency care will sort of spill over is labor and delivery,
Yeah.
because just by definition, that's if a woman is in labor, then it's emergency medical condition and active labor. So that will be the other area where it will spill over.
So what is an emergency medical condition? A couple things. Emergency, again, I hate to just read these, but I don't have a better way to explain them. Emergency medical condition manifests itself by acute symptoms of severe severity, including severe pain, that's such that a prudent layperson who possesses average knowledge of health and medicine could reasonably expect the absence of immediate medical attention to, one, place the health of the individual, or in the case of a pregnant woman, the health of the pregnant woman and her child in serious jeopardy, result in serious impairment of a bodily function, or result in serious dysfunction of any bodily organ or part. And then just because someone presents with a medical condition, or as you were talking about, in extreme pain, if it's the result of a migraine or some severe like substance use disorder, it can still be an emergency medical condition.
Right.
One thing I want to note is about the prudent layperson standard is that the regulations specifically address a practice that they are aware of that applies occasionally, and it's that some plans will deny coverage of emergency services and out of network if they don't, based solely on the diagnosis code. So they have what's called this true ER list of diagnosis codes. And if a diagnosis code doesn't fall on that list, they exclude it and say, hey, you're out of network. We don't provide emergency services out of network. We don't provide any out of network services unless it's emergency service. This was an emergency service. The regulations clarify that that's not permissible. It's not permissible under the NSA, and it's not permissible now under the Affordable Care Act. It has to be, the plan must evaluate using the prudent layperson standard on a case-by-case basis. It can't rely solely on these diagnostic codes to deny. Now, having said that, you can approve if someone shows up with a diagnosis code that is on your true ER list, you can automatically approve based on that. Or you can take diagnosis codes you can factor them in when determining whether it truly is an emergency service. Again, that's just a nuance. And the reason I want to point that out is that was specifically addressed in the regulations, and not only because it applies under the NSA, it applies currently under the Affordable Care Act.
Yeah, I mean, it's clear that, this to me screams like providers and the American Hospital Association were telling the government that, hey, we're seeing this, that payers are just denying these based on codes. And so it was very explicitly called out here in the regulations. I'll just say that, from a provider perspective, this isn't, obviously documentation will be important to document emergency medical condition, but that really should already be occurring for EMTALA compliance purposes. And so I don't know that, this necessitates a whole lot of change from that kind of perspective. Maybe you'll want to be pay a little bit closer attention to it for payment purposes. But, overall, this is the kind of stuff that we've been dealing with for a long time. The providers have been documenting and diagnosing emergency medical conditions and what that means when it's present or what it's not, and their obligations related to that. And now there's just sort of a payment kicker component too. And to some extent, it's interesting because under EMTALA, if there's no emergency medical condition, right, then you don't have to worry about EMTALA compliance anymore. And so you can kind of take a deep breath, and there's one less regulation that you're have to comply with. But now that comes with the kicker of now you start getting into needing to get notice and consent and in order to do balance billing. And so it now adds some additional responsibility after you make that determination. So, it's kind of sort of competing concerns, or there's, you get out from under one and then suddenly you find yourself under a new set of regulations.
So let me ask you a question, that at least the way I understand, a prudent layperson standard is not necessarily whether you're right or wrong, right? Like if I bring my wife to an ED because I reasonably believe, I'm not a medical professional, I reasonably believe that she needs to get to the ED or one of these, she's going to be seriously impaired or have severe pain, and I turn out to be wrong, and she's discharged, fairly quickly afterwards, these emergency services protections are still going to apply, because even though maybe it was an emergency service, maybe it wasn't a heart attack. You had what, bad gas. So
Right.
these are still theoretically going to apply. If I had a good faith belief that, it was an emergency medical condition.
Right, that's right. I mean, it's front of mind because my wife is 8 months pregnant. But yeah, I mean, if I take her to the ED because she's having contractions and it turns out that they're Braxton Hicks contractions or she's not actually in active labor, then I mean, I think a prudent layperson, if the wife is, contracting and having, and feeling contractions, then that would likely be considered by a layperson to be an emergency medical condition. So yeah.
And again, I think most plans, or at least administrators of
Right.
plans, are these protections are kind of currently going on in the ACA. Maybe the reason that it mentioned this specifically is they're aware of some non-compliance, but I would say, I'm sure it's within the knowledge of most payers, whether that be a TPA or an insurer, and how to properly pay in these situations. So here's, I think, maybe the surprising part is these protections can even apply post-stabilization. So these emergency services include post-stabilization services, as long as they're otherwise covered benefits under the plan, unless certain requirements are met. Tim, I don't know if the comments here, but post-stabilization services, again, items and services that are provided by the non-participating provider at the non-participating facility outside of the ED, including outpatient observation or inpatient or outpatient stay. And we'll talk about when post-stabilization services are excluded on the next slide. But I thought that was kind of a big deal. Like suddenly these emergency services protections may apply in the outpatient observation or an inpatient or outpatient stay, where really, I think in the normal course of things, you're not thinking of those as being emergency services anymore.
Right. Yeah, exactly. I mean, and this whole, like you said, we'll get into it in a second, but it's a rather convoluted way to get post-stabilization out from under the NSA. And so that's certainly a new component for providers that they'll have to tackle as they move forward. But it is similar with the state law where the hospitalization that arose from an emergency services are covered by the state law as well. So it is similar in that sense from what we've seen under the state law.
So basically, post-stabilization services aren't going to be covered by the NSA. So balance billing will be allowed if all of the following apply. First, the attending provider determines that the individual is able to travel using either non-medical or non-emergency medical transportation to a participating provider or facility that is located within a reasonable travel distance. The departments have sought comment on what reasonable is, and if reasonable is impacted on whether I have to take the public transportation to get to that other one. I mean, maybe if I had my own car and someone that can drive me there, reasonable might be 50 miles, where if I got to rely on public transportation, maybe it's only 20 miles, right? Like, so they have asked comments in that. The provider and facility satisfy notice and comment requirements. The agencies did release a model notice that you can find on I believe, the Department of Labor's and probably Department of HHS or CMS's website, kind of addressing these regulations. The individual or the patient or an authorized representative of the patient is in a condition to provide informed and voluntary consent. So, they're not under the influence of drugs or alcohol. And the facility satisfies any other applicable state law requirement. So, I mean, frankly, an individual could be in an outpatient observation after coming in for an emergency. And what's weird is it seems like once the provider says, here's this notice and consent, I feel like in transfer, the individual can just say, no, I don't want to go. I'm not going to consent to that. Now, maybe the patient, the hospital at that point, since they would already also be prevented from balance billing, they could say, well, now we don't have to keep you here either. We can discharge you. And I don't know, Tim.
Yeah, I mean, this was one of those areas where I had to go back and read this section a few different times. Again, I mean, it talks about the considerations that you need to think about relate to a person's economic condition. It relates to their ability to understand the language. And so it's just a minefield for providers.
Yeah, and it talks even about minority status of the individual, and are they from a minority group that may have this historic lack of trust with respect to healthcare providers, right? So it's holy smokes, this is not necessarily going to be an easy analysis. And then it looks like, again, unless you want to force the person on the street, if they just say, no, I don't want to be transferred, they can stay there, and this balanced billing protections are going to continue to apply.
And I wonder, I just don't think providers are going to be all that motivated to push patients to consent and sign off on a transfer. I mean, they're going to get paid.
Yep.
They're going to get paid under a formula that isn't, it's not going to be Medicare. It's not going to be Medicare. It's not going to be Medicaid. I mean, these people are covered by a commercial plan. And so, I question how they're going to be motivated. And from a plan perspective, like, how are you going to dispute a claim by a provider that they didn't consent? I guess you call up the beneficiary and say, did you refuse to transfer to an in-network facility?
I think we're going to need additional guidance on these requirements for when you can basically exclude post-stabilization services from these providers. But I think this got to both left. Tim and I are working our way through the 411 pages of regulations on this right now. And I think this is something that kind of independently jumped out at both of us.
And the other thing on that one is, it talks about under state law requirements. And so again, the state law is different in that there's no provision for this post-stabilization. Again, it's been a little bit since I looked at the state law, but my recollection is that, if they're hospitalized subsequent to an emergency treatment, then there's no balance billing under the state law. So again, this post-stabilization analysis and these steps would really, my understanding and my interpretation, and you can tell me if you disagree, Tripp, would be that this is only applicable to ERISA plans because state law would control for the non-ERISA plan.
Yeah, I mean, well, this would still apply to the extent that a state law didn't exist, or
right.
State law was less onerous, if you will, or less protective of the patient.
Right. Yeah.
But you're right. I mean, if there was a state law that was more protective, then you're going to follow that, unless you're a ERISA plan that's generally exempt from state law. But I think a lot of these are a little bit more provider focused than plan focused, because we're not into the payment yet. A lot of this we're going to see how some of it shakes out. We're going to learn as we go, if you will.
Absolutely.
So now let's kind of go over what the requirements for group health plans will be in. And so this is a group health plan is either grandfathered or non-grandfathered. So if a group health plan, either grandfathered or non-grandfathered, covers benefits for any emergency services, and these requirements, as we'll go through them, you'll see are very similar, at least the initial ones, to the ACA. So a plan is not required to provide emergency services. I've never run across especially an employer plan that does not provide coverage of emergency services. And insured plans in the small group market have to,
right, because
it's an essential health benefit on the ACA. But yet those services have to be covered again without any prior authorization requirement, even if provided out of network. Again, this is probably deja vu from this couple of slides ago, without regard to whether the provider or facility is in network, without regard to any other term or condition of coverage other than exclusions or coordinations of benefits, to the extent that that exclusion or coordination of benefit is not inconsistent with benefits for emergency medical condition. I'm going to come back, put a pin in that. I'm going to come back to that. Waiting periods are applicable cost sharing. So obviously, if I'm in a waiting period for a plan, I don't have coverage, I show up, the plan can deny because I'm not eligible for the plan yet. Regulations, again, in a footnote, very specifically address an example of a general exclusion that is inconsistent with benefits for an emergency medical condition. So Tim, you may not be aware of this, but maternity coverage is an essential health benefit. A lot of plans out there, they provide coverage for employees, dependent kiddos, right? Now, generally have to do it up till they're 26, maybe the end of the month they're 26, even possibly some do it at the end of the year in which they turn 26. But lots of plans say, yeah, we provide coverage for the dependent, but not maternity services, right? And that's a permissible exclusion that I've seen fairly often. Regulations note that they have heard stories of plans that, a dependent kid who's pregnant, as you were giving an example to your wife, shows up in the ER with an emergency condition that's the result of the pregnancy, active labor or whatnot, and the plan says, we're not covering that because we don't cover dependent maternity services. That's not permissible because that dependent kid Even though she was a result of her pregnancy, she showed up with an emergency medical condition based on the prudent layperson standard. Protections under the ACA currently apply to that. Protections under the No Surprises Act will continue to apply that in the future. So again, I just wanted to point that out. That was specifically set forth in a footnote that regulators have been made aware of or have seen in prior audits. So if the services are provided by an out-of-network provider or at an out-of-network facility, the group health plan cannot impose any administrative requirement or coverage limitation that is more restrictive than it does for those in-network emergency services without imposing cost-sharing requirements that are greater than in-network. So let's say you have a plan that covers in-network services at an 80%. So you're the patient, your application is 20% coinsurance. And if you go out of network, it's a 60%. So you cover 40%. You show up at an out-of-network facility with an emergency medical condition where these services are applied, the participant's co-sharing percentage is 20%, not 40%. And then you have to calculate the cost-sharing requirement based on this recognized amount. And it's determined in this order of priority. So you start with an amount determined by the applicable state all-payer model agreement. My guess is that this is going to impact very few people on this call because I only am aware of Vermont and Maryland having these all-payer model agreements. This is something under the Social Security Act that states can enter into an agreement with Social Security Administration to try to basically test different agreements that may reduce the overall healthcare spend. Moving on is then if there's no all-payer model agreement, then you're going to move on to the amount specified by state law. Now, the regulations clarify in order for a state law to apply in the situation, it has to apply to the plan, it has to apply to the provider, and it has to apply to the particular item or service that's subject of the bill. So right there and then, if you don't have a specific state law, you're going to move on to the next one. Or in Michigan, I think arguably this Michigan No Surprises Act would apply via specific state law because it covers emergency services. But if you think about it, ERISA self-funded plans aren't subject. They're exempt from Michigan Surprises Act. So that basically takes all of them out. So if you're a fully insured plan in Michigan, you may be stopping at that level. That's what your recognized amount. And if you're a self-funded ERISA plan, you're going to be the lesser of the billed charge, or what we call the qualified payment amount, or QPA. And the QPA is going to be the median of contracted rates for the same or similar item or service in the same insurance market by a provider of the same or similar specialty and provided in the same geographic region. We're going to break that down a little bit in our presentation, but the regs go on for about 15, 20 pages on what all these terms mean. So we're not going to go into that level of depth. And then the last was once you figure out what the cost sharing is, so the in-network cost sharing percentages applied to the recognized amounts, that has to be applied to the individual's in-network out of deductible and out-of-pocket limit, even though the services are provided at an out-of-network facility or by an out-of-network provider. Moving on, the next requirements, again, we will come back to that QPA, but just give me a second. So within 30 days of receiving a clean claim, and for that purpose, a clean claim is a claim that includes all of the information necessary to decide a claim for payment for services. The plan must determine whether the billed services are covered by the plan, and if they are, send a quote unquote initial payment or a denial. And there's no, I guess, rules on what the initial payment is, but my guess would be if the plan has never kind of worked with the provider, it's probably going to send whatever the QPA is, what it determines the QPA is. If it's kind of had this back and forth with the provider and they've already had kind of they've gone through the IDR process before, or they've previously come to a network agreement, they're going to send that amount. And then later they have to make a total payment equal to the out-of-network rate to the extent that exceeds the applicable cost sharing less the initial payment rate. And when that payment is due is really going to be depending on how you're going to figure it out. And you're going to go through this in the order of priority. The amount determined by the all paid or model agreement. Only probably going to apply if you're in Vermont or Maryland. Amount determined by specified state law. If you are, if ERISA self-funded plan or you're operating in a state that doesn't have a state law, you're going to move on to an amount agreed upon by the parties. Again, that's permissible. And then if all else fails, then you're going to, so all payer model agreement probably has a payment deadline. Specific at state law probably has a payment deadline that applies. Amount agreed, as soon as you agree to it, you're probably going to say, okay, I'll send it over to you ASAP. And then if you go through IDR, once IDR is finished, you have a certain amount of time to pay that. That's why the timeline may vary. So again, but to the extent that you have already had agreed an amount and that you made that as your initial payment, you're done after the initial payment. So QPA amount for self-funded plans, the QPA is determined for the self-funded plan using the contracted rates of all the plans of the plan sponsor, or at the plan sponsor's selection, the TPA, as of January 31, 2019, and indexed inflation, or such later date as the plan came in existence. And if you think back to how you calculate the average, or what was it, the average, the mode, and the median, right?
Right.
The median rate is you line up all your payment rates in a line, right, from lowest to highest, and you pick the one in the middle, if it's an odd number. If it's an even number, you pick the two in the middle and you calculate the average. So that's essentially how you're going to do it. Now, you as a plan, remember that you have kind of this option. We can ask your TPA, can you calculate the median rate just across my plans? But you could also say to the TPA, I want you to look at your entire book of business. Either one of those is permissible. If the TPA is willing, you could say, hey, will you look at what my median rate is for my plan? And the median rate is across your whole book of business, and we're going to pick the cheaper one. That's also permissible. TPA may say, we're not doing that. Or realistically, if you're basically relying on all of the TPA's networks, it may not vary from the plan to what their overall book of business is. For fully insured plans, the QPA is determined again using the contracted rates of all coverage by the insurer. So it's the entire insurer in the same market. So individual, small group, or large work as of January 31, 2019, and then again indexed for inflation. So you can see there's going to be a lot of owners here on insurers and TPAs of self-funded plans. There may be some wiggle room for you to work with your TPA if you're a self-funded plan to try to find a slightly median rate, but I wouldn't be surprised if the TPA says, listen, we're trying to do transparency stuff. We're trying to do, put together these comparative analysis of NQTLs for you. Now we got to do this. We're calculating the median rate across our book of business, take it or leave it, right? I wouldn't be surprised if that's the answer you get back. The contracted rate, again, is the total amount, which includes cost sharing that a group health plan or self-funded or insurer of a fully insured plan has contractually agreed to pay to a participating in-network provider, and that includes through a TPA and a PBM. So keep in mind, if you kind of carve out your prescription drug benefit, you may be working with your medical TPA and your PBM on the prescription drug to do this kind of separately. Now, if you're using one organization that does this all together, maybe that's a little bit easier, but just keep that in mind. One thing I want to point out here, and again, this is kind of, they kind of hone in on this on the regulations, is the recognized amount, which is the amount that determines participant cost sharing, remember, may not always equal the out-of-network rate, which of course is the total payment that the plan has to pay to the provider. So, because if you look at, the first two elements of the recognized rate, the out-of-network rate, are the same. But if you're like a self-funded plan, you have to move into the third. Your recognized rate is going to be the lesser of the QPA or the bill of charge, and the amount of the out-of-network rate is either going to be the amount agreed on by the parties or the IDR amount. So again, this might require a plan to make a payment before the applicable deductible. The regulations actually give an example. We're almost done here, folks, too. So I just want to, if you're home in there, but got something else come up, just bear with us for a few more minutes. Individuals enrolled in the high deductible health plan with a $1,500 deductible. That individual is not accumulating any amounts towards the deductible at the time when they need ER services, which are received in an out-of-network facility. The plan determines that the recognized amount is based on the qualified payment amount, the QPA, and that amount is $1,000. So since it was deductible is $1,500, the individual is responsible for that entire $1,000. So they're going to pay $1,000. The plan, though, determines that the out-of-network rate with the provider is $1,500 through the IDR process. So this is going to require the plan to pay $500, even though the participant has not satisfied their $1,500 deductible. Now that $500 is not going to accrue to their deductible, but so they still have to satisfy that on other services. But the plan will actually have to pay before it would normally have to do. The regulations also clarified that this would not cause a plan to fail to be a qualified high deductible health plan for HSA eligibility purposes. Tim, I'm going to go out on a limb and say you don't have much to add here.
No, other than this is a nightmare.
Finally, a notice requirement applies. There's a notice and comment requirement applies to providers. We're going to get into that more in September. But the NSA requires providers, I'm sorry, I should say plans. The NSA requires plans to make publicly available and post on a public website of the plan. I'm not aware of any of my clients' plans, not the plan sponsor's website, the plan's website, a plan, and including each ELB for an item or service with which respect to the NSA applies the following information in plain language: the restrictions on balance billing in certain circumstances, applicable state law protections against balance billing, requirements under the NSA, information for contacting the appropriate state and federal agencies in case the patient believes that the provider or facility violated restrictions on balance billing. That's a whole mouthful. Fortunately, the Department of Labor provided a model notice. It can be found in the department's No Surprises Act website. It doesn't have to be used. I don't know why you wouldn't use it. I don't know why you try to craft your own. It does require some modification. The question that I tried to answer before this webinar is, when do you have to provide it? Is this an annual notice? Is it just an initial notice? Right now, the statute or regulations don't clarify. Other than it has to be on the EOB. I think conservative employers will probably make this notice a part of their annual open enrollment and initial open enrollment materials. So again, I think you should go out, look at that website. If you need help customizing it, give me a call. We can work through that. But I think as we roll up for enrollment for the first plan year that begins in 2022, I think we should get these notices in those annual open enrollment materials. If you don't have enough time, or you've actually already had this would be really early to have enrollment for a 1/1 plan year, but you make a mistake, I don't think it's the end of the world, because there's no express requirement that it be in those enrollment materials. But I think that's going to be a good faith interpretation on a go forward basis.
Yeah, I was just going to add that, providers do have notice obligations as well. And so again, that's something we'll talk a little bit more in September, and you'll still have plenty of time to kind of gear up for that. But, there's language requirements, how many languages you have to post some of these things in. Again, we'll focus on that a little bit more, but I just kind of want to put a pin in that and make sure the providers that are listening are aware of that requirement too.
So we will take questions. I did kind of skip over that slide. I don't see any right now. So I'll kind of address our last little issue and then see if any roll in. Tim is going to be back with me on Wednesday, September 15th for our next Employee Benefits Lunch Break Series webinar. No Surprises Act 2. This is going to be the non-emergency services provided by non-participating providers and participating facilities. Again, to reiterate what I said initially, I think that I think is still going to be applicable to plans. So if you're here attending on behalf of a plan, I think you should still come. If you're here at a provider and thought, this was only relatively worth it, I think it's that session is going to be more worth it. And then I don't think we're done with these webinars. I think we're definitely going to do one on the IDR process, but the regulation, these current regulations said we're going to come out with additional regulations on the IDR, and FYI, they may not be before the end of the year. So when those come out, we'll try to digest those and maybe plan a part 3, or if we see kind of, the Department of Labor right now, I think it likes to do a lot of things, your sub-regulatory guidance like FAQs. If we see some big FAQs come out, we'll schedule an interim webinar here. But again, plan on joining us next month, September 15, to go over the non-emergency services when the least protection.
Well, and this is an interim final rule is what we're talking about here. And so there are comment periods. You could comment on the notice up until August 12th, I think was the last day you could provide comments on the notice. So there's possibilities that things will change.
Yep.
So, obviously depending on the amount of change, we'll hold a webinar or issue some sort of notice to a client alert to people so that they're aware of what those changes are and how those impact what we had to say. I mean, we're also going to be talking in March to the healthcare law section for the State Bar of Michigan, where we'll be talking about some more of this. And so, we very well maybe sometime next year revisiting this and talking about lessons learned and sort of practical experience from dealing with some of these laws.
And this is an IFR, so it's interim, but to the extent there are changes in the final rules, we still can rely on these basically through the final rules and probably up to sometime after the final rules are issued. So just because these are interim, don't think like, they're not actual guidance. It still is actual guidance. There just may be changes that would likely apply on a prospective basis. With that said, thanks again for joining us today. Our contact information is up there. I didn't see any other questions. So thanks again, and everybody have a great month, and we'll see you back here on September 15th.